Good morning, Ms. Visor. Ma'am, you're charged with theft. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On September 15, 2024, officers were dispatched to 303 Memorial City Way in Harris County, Texas for shoplifting. Officers made contact with the complaining witness. The complaining witness, a Sephora loss prevention manager, stated that the defendant was observed entering the store with a big Target shopping bag, along with another female and two males. They were observed concealing merchandise and exiting the store past all points of sale without purchase. The complaining witness stated he went after and apprehended the defendant in the parking lot. The complainant then instructed the defendant to return to the store, but the defendant refused, dropping the concealed merchandise and took off running. The complainant alerted mall security, who tracked the defendant and placed her in handcuffs, returning her to the store. The officer made contact with the defendant. The defendant stated she was a single mother and that she shoplifted from Sephora due to her situation. The total amount was $1,939.
$1,900.
Yes.
Let's go through this, shall we? 2013 theft, 2014 failure to identify, 2015 theft, another theft, 2017 theft, 1, 2, 3 suspended license cases, all in 19. Now, in 19, another theft. 22 robbery, 22 tampering with a government record, 22 false statement to obtain credit. And now another theft. Not a felony, guys. This is number 6. Apparently, we've not been getting the message across to you, Ms. Fleischer. As far as I see, this should, at the very minimum, because you already have one state jail felony conviction that you obtained in 22. So now this makes this a 2 to 10 third-degree felony. That happened on the robbery case. Can we now make this a second-degree felony? You're looking at 2 to 20. Yep. You, by picking up a case like this, had they done what they probably should be looking at 2 to 20 in the penitentiary, where typically on a case like that, if you're found guilty, looking at, I don't know, 12 years, that's what they start out at on second-degree felonies. That is what you should be facing, Ms. Fleischer. I don't know why you're with me, but that's what you should be facing in this case now. Where was this? Was this in a mall?
At the mall, and it was particularly a Sephora.
Which was it? Galleria? Was it Deerbrook Mall? Baybrook Mall?
Memorial City, so I don't.
You said, what was it?
Memorial City.
Memorial City. Okay. I'm now prohibiting from you to going to Memorial City Mall whatsoever, from going to any Sephora whatsoever. Do you understand?
Yes, sir.
I'm now also going to look at all the theft cases that you have here, and I'm forbidding you from going to any of those stores as well. If I find that you do, I'm going to put you in jail and I'm going to make your bond extremely high. Do you understand, Ms. Fleischer?
Yes, sir.
I will do everything in my power to protect the public. What do you do for a living, ma'am?
Right now, I'm trying to go work for the city of Houston. I'm trying to get a job.
So you don't even have a job. I am now making that a condition of your bond that you get a full-time
Leg,
job.
sir. When this incident happened, they broke my leg, so my leg is injured.
I'm making it a condition of your bond that you get a job.
Yes, sir.
And I'm going to bring you back here in 2 weeks. And I want to see what you have done to get a job. And if you've done nothing, life is not going to go well.
She expressed to me that she has some concerns that when she goes to apply for a job or to search for a job, that the possibility of them seeing the ankle monitor on her leg would deter her from the possibility of getting hired, which I believe that that's a legitimate argument, which I was going to ask. Your Honor, would the court be amenable to waive that for at least 3 weeks to see if she could go apply for some jobs without the requirement of the ankle monitor being on during that initial process of job seeking?
When is the last time you've had a full-time job, Ms. Bison? A real,
The last time I had a full-time job was like, I basically did 3 years just a while ago. Like, so it's maybe like 3 years ago.
And Judge, for your information, I've already provided the court with the competency examination. I spoke with her and I had an opportunity to speak with the person in the psychiatric hospital that gave me a prescription list for her that she's taken for her anxiety, bipolar disorder, panic attacks, depression, post-traumatic stress disorder, and she currently has a psychiatric doctor in the civilian world as well. So
I would venture a guess, Ms. Visor, that your lengthy and rich criminal history will pose more of a problem than your ankle monitor. And the fact that it's inconvenient to you makes no difference to me. The only thing I care about is the protection of my public, my Harris County. That's what I care about. And with an ankle monitor, I know where you are. And I've forbidden you from going to many, many stores in this county. And if I don't have the ankle monitor on, I don't know if you're in compliance or not. And God knows I can't take your word for it, right? The only way I have of knowing whether you comply with these conditions is that ankle monitor. I'm even paying for it for you, which is saving you around $500 a month. You also need to be aware that it's very possible, and they've already told me that they're going to seek to file this as a felony charge. So you need to be aware that that's something that's on the horizon. But you got to understand, when it continues to happen over and over, over and over and over and over and over and over again, there are some serious consequences that may arise. And just because it's inconvenient for you when the last time you had a job was 3 years ago, makes no difference to me. My only concern is my public. So I'm not taking the ankle monitor off.
thank you very much.
I'm sorry, Mr. D, but
Yes, sir, Your Honor. Thank you, sir, for addressing it.
for sure.
I've been told that
Where's Mr. Walker now?
he was just here.
Mr. Walker, come up. Deputy, I might need you real quick, ma'am. Okay.
The issue is that he's testing negative, but it's showing for the lab result diluted. And Judge, I don't know why it's showing that, but
I know why.
well, you know, I don't know how much, my question would be, how much water does someone have to consume for it to show
They
diluted.
have other things that you can take at high times that will dilute it. It's not just a matter of drinking 15 gallons of water. There are other masking agents that they use to dilute, to,
If someone takes a diuretic.
well, I don't know about a diuretic, but I mean, just there are other things that you could take at high times to mask what you're doing. And I told you now, a dilution was just as good as testing positive with me. With all the drama you've given us, absolutely not.
I've been on the diet, I've been on a strict diet, so I haven't been drinking a lot of soda, or I just been, and I barely drink water. I mean, I barely drink juice. I've been drinking a lot of water. I've been cleaning out my system, flushing out my system to make sure I stay clean. Cause like you told me, and like I made sure that my lawyer know, I'm trying to stay clean, trying not to mess up in any way. Sir, I'm telling you, I have not.
Follow the law test. They've not been able to confirm the negative.
I've been completely clean, sir.
Let's do, I want to do a deeper dive because I want to know more about the dilution. I'm not taking your word for it. Like
Sure.
you telling me something goes in one ear, goes out the other ear.
But I'm telling you, I've been listening to you. I do not want to go back to jail. You know, everything I'm supposed to do. Like I said, I've been on a strict diet a lot, and I have been drinking a lot of water only because to flush out my system to get the THC out. That's it. I've been drinking a lot of spring water, cucumber water, and juice, and cucumber.
Because of your prior positive. you
Yes,
had,
yes.
Not because of a new positive,
No,
correct?
because my prior positive you got on me, you said if it happened again, and I've been drinking a lot of cranberry juice, a lot of water, that's flush out your system. That's just natural way I've been fine to get out all the THC out.
I already told you what was going to happen. if I
Yes, sir. Yes, sir.
Diluted sample, and they're telling me, how many diluted samples are you saying? So regardless, I'm not making, you can't, there's a diluted sample, so you can't really tell because it's all masks. It's all masked because of whatever he's doing to dilute the sample. So that's the problem, is he's doing something to trick us into diluting the sample so we can't tell what he's taking. Mr. Walker, you have open at this time a possession of marijuana, 2 to 4 ounces, a possession of a controlled substance. You pick up another possession of 4 ounces to 5 pounds. You have a DWI with a child passenger, which is, what is it, like a 3-year-old, right? And then the car is filled with marijuana smoke, and you have a veritable pharmacy of dope in the car with you. This isn't the first bond violation, and you also have a gun. You have so many bond violations that your bond is now at 45,006 on all of our cases. And I told you,
Seriously.
when you got out, if you had any issues, you would be going back to jail.
Yes, that's why
I told you no diluted samples. I said no positive samples. Strict compliance was
I'm not
required.
doing no purpose. Just I didn't. I
You
literally-
have now five diluted samples.
And this, just so you can see this. It just comes back as an abnormal levels of keratin, but everything else is normal.
I'm taking everything you say seriously, Judge. Everything.
You can't tell that though. You can't tell if he's using cocaine, benzodiazepine, phencyclidine, because it's diluted.
I will take another test right now.
I don't care about tests now. The 5 prior tests that you've had have all been diluted. 5 prior tests have been diluted. I'm now revoking your bond again. Goes with you.
Should we give him a test on Thursday and see if it
No,
comes back? And
no. Mr. Walker, you have a freaking pharmacy of illegal drugs in your car with a 3 to 4-year-old in a plume of marijuana smoke.
I've been taking everything you say
Time
seriously.
and again, I can't get through to you.
I've been taking everything you say seriously.
No,
I'm completely sober.